This is Duke University.
Thank you so much. Thank you for having me and for inviting me to welcome our guest, this is the first time that I've met Bahar Azmy, but I've heard about him and about his work both at Seton Hall and work of the CCR, where he's now the legal director for a very long time. And that work has been enormously important to, of course, the individuals that Seton Hall's clinic helped, litigated on behalf of, and whose rights it, in each of those cases, defended, but also enormously important for the rule of law and good governance in this country. You know, when I was reading about some of the work that are led at Seton Hall, I was brought back to the period immediately after 2001, and really was shocked again to remember some of the practices, some of the most extreme practices then in place, which are not in place now, and due in no small part to the work of Bahar and others that were really tireless during that period. So, for example, I had forgotten that we couldn't even at that time get the names of the detainees. It was sort of the pre-project was figuring out who it was that was being detained without rights of communication and without counsel and without right of review. So the first part of that project was in collecting names largely from family members that had come forward with basically stories of disappearances. So things are not quite that way, but then the question is, well, how exactly are things now, and are we looking realistically at our current practices in terms of detention, in terms of rendition, in terms of review of detainees, release of detainees, where, how, and of course also the question of trial by military commission. So there's been just a remarkable process of sort of normalization, such that it's almost as though things were done in such an extreme manner immediately after 2001 that it all looks good by comparison. My mother once told me this story about this man who goes to a rabbi and says, I've got 5 kids, I've got a tiny house, everybody's crawling all over each other, I can't think, I'm going out of my mind, and he says, buy a goat. And that, I'm still very unhappy. Buy 2, these are all like coming into the house, right? So he's got like this whole menagerie, and finally he goes one day and he's going to say, what do I have to get now? And he says, rid all the animals. Guy's happy. We've gotten rid of all the animals, but what are we really doing? All right, thank you.
Generous introduction, and thank you for ICS and Francis and Lee for inviting me. I'm quite honored to be giving a keynote address, and particularly ICS's 40th anniversary. As Adeline mentioned, I'm the legal director of the Center for Constitutional Rights, which is a nonprofit organization started in the 1960s in support of the civil rights movement in Mississippi, and which has for 40 years since attempted to use the law in creative ways as a tool for progressive social change. And in particular, after the attacks of 9/11, has been very actively involved in attempting to defend human rights and limit the excesses emerging out of the so-called war on terror. CCR filed the first habeas petitions in 2002 on behalf of Guantanamo detainees, represented Canadian citizens subject to extraordinary rendition, has filed actions in foreign courts seeking accountability for torture and other abuses by Bush administration officials, sued private military contractors for torture and Abu Ghraib, and represents individuals either incarcerated or Muslims in the New York, New Jersey region subject to surveillance by the New York Police Department. And my talk today is sort of a ponderous field. It's called Transnational Strategies for Justice in an Age of Endless War. And what I really intend to do is offer a reflection on 10 years of challenging human rights abuses and seeking forms of transnational justice in the war on terror. A war that currently appears to have no obvious stopping point. So for the past 11 years, largely in the name of this undifferentiated war on terror, the United States has pursued policies that have arrogated dramatic and arguably unprecedented power to the executive branch, while contemporaneously abandoning a number of fairly fundamental commitments to international human rights law. And during the early to middle years of the Bush administration, as Madden suggested, as news of extraordinary renditions, torture, so-called torture memos, warrants, wiretapping, etc., spread, there became a widely accepted narrative that the United States had abandoned constitutionalism and was acting beyond the rule of law. And yet, although President Obama has abandoned some of the worst excesses of the Bush administration, he has 11 years hence clung to the basic legal architecture that situates many of the continuing extra-constitutional practices in the rhetoric of war and national security, and has curiously managed to do this without the expected hue and cry from critics of the Bush administration. So this suggests that the arguably extra-constitutional state practices has, as Madeline said, become normalized, which I think is a phenomenon that is as troubling as it is paradoxical. So a couple of the questions I want to include in my reflection is, how did we arrive at a place where we now accept as normal what was once perceived as exceptional? And what does this particular transformation portend for advocates of social justice and transnational justice in the face of this endless war? And to frame this recollection, and if you'll indulge me, I want to start, which is in part personal and part institutional, on behalf of my organization, and somewhat detached. I want to start with a story about my client. I first saw my client on a TV screen. Before my initial meeting with Murat Kurnaz in October of 2004, 3 months after the Supreme Court ruled in Rasool versus Bush that detainees could file habeas petitions to challenge the legality of their detention, camouflaged U.S. military police escorted me. I was at the time the third civilian lawyer to enter the inner sanctum of Guantanamo's Camp Echo. They escorted me through several 15-foot-high locked gates and into the guard booth of the notorious military prison. And on my way into the guard booth, walking across gravel made bright white by the blazing Caribbean sun, my status as a lawyer, looking much like this, clean-shaven, a tie, formal shoes, was punctuated by the sound of machine gun fire in the distance. The military showed me the surveillance they would employ during my meeting with Murat. He appeared there on a video screen waiting for me. The image was dark and blurry like the grainy picture on a store security camera, but it was also unsettling. I could see a man with a beard and hair befitting a prehistoric warrior. President Bush claimed that everyone in Guantanamo was the worst of the worst, sworn killers, enemies of civilization, so this image was almost designed to unsettle me. The military then told me that Murat would be chained to the floor and advised me that if he attacked, I should simply push back, hit an alarm, and they would come rescue me. 15 minutes into this experience, the military had cast him in sort of alien, monstrous terms. He was a Hannibal Lecter who prayed 5 times a day. So I braced myself and prepared for our meeting, and when the door to our meeting room in Camp Echo opened, he was seated, squinting at the incoming sunlight. He was dressed in a short tan shirt and cotton pants, and a flowing beard and red-brown mane of hair that made him look like someone who had been shipwrecked on a desert island, which, in a sense, he was. He shook my hand and motioned for me to sit across from him in a flimsy plastic chair, as if he were welcoming me to tea in his home. I tried to sound confident. Murat, my name is Bahar Azmy. I am a lawyer. I do not work for the U.S. government. Your family has asked me to help you. I handed him a handwritten note from his very worried mother to help convince him I was on his side. This was obviously an issue because in the 2.5 years he had been there, he had never talked to anyone who was not either a part of a military or an interrogator. Would he trust me? Still, the sort of the simple honesty and loving tone of this note moves me. It read, "My dear son Murat," in handwritten Turkish, "you will be visited by an American lawyer whom you can trust. His name is Bahar Azmy. Murat, your brothers go to school, and we have been for a vacation in Turkey. We were shopping with Negahanda, his wife, and she is loving you." And so as I watched his pained expression while reading his first message from home, his first taste of humanity in years, I felt as though I was delivering a crumb of bread to Robinson Crusoe. I continued to explain that his mother had been fighting for years back home, and I had filed a case for him in court and attempted to challenge his indefinite detention. He had never been charged with any crime, let alone put on trial. Indeed, because he had been held incommunicado for almost 3 years, he had no idea anyone even knew he was alive, and he certainly did not know he had a lawyer. I also told him I was born in Egypt, was Muslim, and a law professor with great faith in the American legal system, a faith that, as you'll see, has been considerably modulated since our 2004 meeting. He asked, "You have sued President Bush?" "Yes," I answered. "You and I have sued him together, and I will do everything I can do to help you." And so to my relief, he said with a very heavy German accent, "This is gut." So how is it that Murat Kurnaz, a then 23-year-old German resident of Turkish descent and one of the about 760 men who found their way to Guantanamo, and I, the then 34-year-old liberal law professor, as one of eventually hundreds of lawyers to represent the detainees, find each other in this strange, brutal, isolating place? So think about this question, about the much broader struggle for and challenges for transnational justice in Guantanamo and other outgrowths of the American war on terror. I want to start by describing the legal and political architecture that was constructed to justify Guantanamo and which carries through today in metastasized, if somewhat modulated form. I'd say Guantanamo, having been there a half dozen times, is one of the strangest places on earth. Was found the mix of brutality and banality and violence and boredom very unsettling. And there's a McDonald's there, and there's a Starbucks, and a PX that looks like a Walmart, which if you lose yourself after the third day, you find yourself saying, "Oh my God, the sneakers are tax-free," which is all unsettling because 2 miles from this these little sort of outgrowths of Americana is a fully constructed project of dehumanization. And that project has a number of features and a number of facets of evisceration or erasure. A legal evisceration, a physical evisceration, and a cultural one. We'll start with the legal one, which is the most obvious and probably the most important. First, the Bush administration denominated, on the president's say-so, everyone in Guantanamo as a so-called enemy combatant, which is a peculiar term, without much of a real pedigree in international law, but it was designed clearly to take them out of the protections that would traditionally apply to individuals under the Geneva Conventions, and largely for the first time in modern American history, to deny a class of human beings the protections of any law whatsoever. What I always found particularly cynical about the Bush administration practices is they justified publicly the detention of so-called enemy combatants by taking it, arrogating to itself some power from international law, because international law does grant some power to detain individuals to prevent them to return from the battlefield. But it took that power at the same time. It rejected simultaneously the limits that necessarily are supposed to accompany that grant of power, namely treating people humanely. And so, there's a sort of clearer definition of Madisonian tyranny at work. I'm not sure what that is. And the second part of the legal project of evisceration was to deny any substantive application of law, constraining law, domestic, constitutional, or international. In December of 2001, a notorious Justice Department lawyer, now notorious John Yoo, wrote a legal opinion urging or advising the military about how to stage detention operations outside of the jurisdiction of the U.S. courts, and recommending Guantanamo. He rejected the Midway Islands and the Wake Islands because there was a stronger argument the courts would have jurisdiction there. And specifically, you wrote that the government needed to avoid jurisdiction in order to protect, quote, the system that has been developed. And I think it's a very telling phrase. What is that system designed to protect? Remember, Guantanamo was not designed as some sort of humanitarian outpost to protect prisoners of war outside the battlefield. Obviously far from it. Nor was it ever designed to adjudicate guilt or innocence in a traditional sense. It was designed as a place to conduct interrogations, endless, brutal, lawless interrogations. And that system depended upon creating an environment of complete and utter isolation. In the words of a CIA interrogation manual in which the interrogation techniques were based, the milieu in Guantanamo should impose feelings of, quote, dependence, debility, and dread, designed to instill utter hopelessness so that prisoners realize their resistance to their interrogators is futile. That leads me to the second interlocking form of evisceration, a physical one, through torture. The goal of this interrogation model of isolation is to, quote, create maximum amount of mental discomfort, unquote. Effective questioning attempts to reduce detainees, quote, to animal-like instincts, and involves, quote, methods of inducing regression of the personality to whatever weaker level is required for the dissolution of resistance and the inculcation of dependence. With techniques like sensory deprivation, psychological torment, self-inflicted pain, humiliation, total isolation would give interrogators total control. As one interrogator told the Bosnian detainee, Salah Ben Sayed, he said, "There is no law here. We are the law." The third type of evisceration was critical as well, a cultural one through an iconography of terror. The administration called the detainees in Guantanamo, as I mentioned, the worst of the worst, hardened killers who brought down the towers, or one colorful phrase by General Richard Myers, quote, individuals who would gnaw through the cable wire of a C-17 plane. The administration disclosed pictures of detainees bound and hooded, slumped like animals in Guantanamo transport planes, and again constrained like animals in cages in Camp X-Ray. This was intentional. These individuals were superhuman, monstrous, so that no normal techniques of containment would apply. They had to be isolated, imprisoned on an island fortress. No regular techniques of interrogation wouldn't be enough. We needed enhanced interrogation techniques. And because of the vastness of this menace, the war on terror had to be a global war on terror. And the strategy of containment had an obvious racialist or religious cast. As Sartre said of the French occupation of Algeria, quote, one of the functions of racism is to compensate the latent universalism of bourgeois liberalism. Since all human beings have rights, the Algerian will be made a subhuman. So this central narrative took over what was in reality 700 individual and sometimes heartbreaking stories about real human beings. But this narrative and the corresponding need for total state control made Guantanamo not only possible, but in the public's eye, necessary. And I want to pause here for a second on the aspect of legal evisceration. So why was it so critical for the administration to deny jurisdiction of U.S. courts? It seems like a technical legal point, but it's fundamental. Most obviously, if courts have jurisdiction, they can apply substantive law, substantive legal constraints on operations of officials there who otherwise were acting with complete discretion and will and power. But with courts often comes with jurisdiction often comes something else that we often disparage in our litigious culture, which is lawyers. And lawyers, in one narrow sense, are problematic because they can tell their clients to not participate in interrogations. But I think more fundamentally, lawyers threaten the sine qua non of Guantanamo at the time, because lawyers can bring hope. They can offer some coherence and future orientation to the disorientation of endless and chargeless detention. Tell me your story. I will tell the world. I will help you. Trust me. The need to deny lawyers should be obvious enough, but it was specifically confirmed in an actual affidavit submitted to a court by a military officer in the case of U.S. citizen Jose Padilla in support of the military's attempt to deny him access to his civilian lawyer. This was transparent. The affidavits said, that told the court, for our efforts in sustained interrogation to succeed, maximum isolation must be applied. The detainee cannot be left to feel that help is on the way. So it's in this isolating context that law is the aspect of human dignity that stands in opposition to Guantanamo and is a form of resistance to state violence. And for this reason, one of the pioneering lawyers in this struggle early on, Joe Margulies, explained a simple legal strategy we had to pierce the heart of Guantanamo in the beginning. He said, if we open it up, they will shut it down. So I've explained a bit about how detainees like my client got there without going into the details of the Kafkaesque reasons for his detention. How did I get there? And I and other lawyers. In February 2002, during the still raw post 9/11 climate, my current organization, the Center for Constitutional Rights, filed a petition for habeas corpus on behalf of a number of Australian and British detainees detained in Guantanamo Federal Court in Washington. Habeas corpus is this ancient legal entitlement that we have enshrined in our Constitution that requires the king in England, or in our case, the military, the president, to justify the factual or legal basis of the detention. Literally means show me the body, present the body and the reasons for the detention in court. This was, at the time, a crazy filing in that climate. But it was with no hope of success, but it was fueled only by principle and a hope or an expectation that the tides would change. And indeed, the lower courts threw out the cases fairly quickly. But in 2004, the Supreme Court decided to hear the case, the Rasool versus Bush case that I meant earlier, which ultimately authorized my visit to see Murat. In defending incommunicado detentions in Guantanamo, the administration had argued to the Supreme Court that even though the United States had complete jurisdiction over and control over the naval base in Guantanamo, it was barricaded from the Cubans. The United States had its own access to its own water supply, and the Cubans hadn't set foot there since Castro took over. Even though it had all the attributes of United States territory, these individuals are still foreign nationals on foreign soil, and therefore the courts would have no jurisdiction to hear challenges to their detention. And one might have thought, given the court's history of deferring to the executive branch during times of crisis or national security, that the court would agree with the administration. But in the 2 years since CCR had filed the petition, things had changed. And detainee lawyers didn't challenge or attempt to humanize the clients or challenge the claims of dangerous, nor could they challenge the factual basis of their detention at the time. After all, the named petitioners in the Supreme Court had no idea they even had lawyers. The government refused to let them know they had a case in the United States Supreme Court. So instead, the lawyers changed the narrative to one about not about the clients, but about this idea about the rule of law and the court's guardianship of basic American values. And to help tell the story that the U.S. had lost its way, a claim that I think one could question in light of Japanese internment, mass incarceration, and other forms of racism and injustice in this country. Still, to present that narrative, lawyers filed numerous amicus briefs, friend of the court briefs, from a panoply of institutional vanguards. There were the 500 English parliamentarians who filed a brief, retired generals, former diplomats, retired judges, international governments. Fred Korematsu himself filed a brief in the court. They all said, America, this is not right. You have lost your way. Please return to the America we know and trust. And then days after oral arguments held in that case, pictures emerged from Abu Ghraib. This is what was happening inside the black box that the United States wanted to keep closed. So the Supreme Court ultimately agreed with the rule of law forces and ruled that detainees have the right to file habeas corpus petitions challenging the legality of their detentions in federal courts. And so for lawyers involved in these cases, and indeed for the public at large, at least measured by editorial pages, this seemed like a genuine victory, a genuine rights moment. And it fit within the progressive legal model that lawyers often share, like myself at the time, in which there's this sort of linear expansion of rights, a continuing process where the government learns from its mistakes, corrects past injustices, and rectifies a repressive course temporarily undertaken during wartime. And so armed with this liberal law professor optimism, I'll put it in scare quotes, I arranged to meet with my client that I described above. And in our meeting, I promised him we would have an opportunity to present evidence before a court of law, and they would rule on the legality of his continued detention, based on what I knew of the preposterous allegations against him that the government was ultimately forced to give to me and him after the Rasul case. His rights would be recognized. A court would set him free, I had no doubt. And habeas corpus petitions were filed on behalf of other detainees as well by a broad swath of legal counsel CCR had mobilized from across the country, corporate firms, academia, public defenders. They were known collectively as the Guantanamo Bay Bar Association. Lawyers screamed down to the base, if we can open it up, we will shut it down. And as a result of these client meetings, attorneys steadily pierced through a number of the myths that had previously propped up the Guantanamo experiment, that detainees were in fact dangerous or terrorists. That revealed that only 8% under the government's own allegations were members of Al-Qaeda, 90% were turned over to the United States by the Pakistani government or the Northern Alliance forces during a period of time when the United States was dropping flyers offering bounties of wealth beyond her dreams, and dropping them at a rate that Rumsfeld likened to snowflakes in Chicago during Christmas time. And they also propagated the myth that detainees were treated humanely, told stories of unbelievable misery and abuse. Amazingly, the tide of public opinion slowly turning against Guantanamo. Strangely, however, things were not moving in the courts as I had planned. Our promise to the detainees that we will file these petitions, we will present evidence, the court will set them free, was not coming to pass. The government didn't see Rasul as the genuine rights movement we saw it as. They took the position that the case only gave courts jurisdiction to accept habeas petitions, but because they're still foreign nationals detained on foreign soil, they had no substantive rights which a court could enforce. So the clerk could accept the petition, but no judge could act on it. The court could listen, but could not speak. The political branches also weighed in with multiple attempts to limit detainee access to the courts and reverse the already limited ruling in the Rasool case. Indeed, in passing the Detainee Treatment Act of 2005 and then the Military Commissions Act of 2006, Congress, in 2 short years, suspended the writ of habeas corpus more times than had been done in the previous 100. And it did so for a population defined by their religion. The promise of Rasool's legal victory was then seemingly quite empty. Bahraini prisoner Jamal al-Dosari wrote to his lawyer in 2005, about his experience in 2005. One day the military gave me a piece of paper that laid out the allegations against me. I had been in Guantanamo at that point for 2.5 years. My lawyer later told me that I received this paper as a result of a U.S. Supreme Court ruling that detainees were allowed to have court hearings. We never got the promised hearings. Instead, we went through a military hearings process in Guantanamo, which were not shown any evidence or allowed to have lawyers. All we got was this piece of paper. So without meaningful recourse in the courts, the task of lawyering became different. We had to transform the undifferentiated wash of the terrorists in Guantanamo by telling hundreds of individual stories, which we did. We talked about their families, talked about the abuses they suffered in dark quarters of Guantanamo. We attempted to fatally undermine the competence, truthfulness, and integrity of the Bush administration's judgments. We could eventually say and demonstrate these were far from the worst. The worst, some were in fact chicken farmers, innocents in the wrong place at the wrong time, turned over for bounties, not captured on the battlefield, some kidnapped from Sarajevo and places like Gambia and Zambia, hooded, cuffed, and rendered in the dark of night to Guantanamo. For myself, even though I had no opportunity for a court hearing on Murat's innocence, I told his story everywhere I could, the preposterousness of the government's allegations against him and the brutality of his treatment. The audience, again, was not a court of law. It was actually primarily the German government. No courts were releasing individuals, but lawyers were agitating for home governments to negotiate for clients' release. We were demanding that the German government accept responsibility for his fate that they had cynically put off for a number of years and negotiate for his release. I think it's fair to say that by 2007, confidence in Guantanamo went generally the way of confidence in Bush, Cheney, and Rumsfeld, more broadly. Still, it's not like lawyers and activists at that time had totally abandoned rights talk. Indeed, in 2008, we convinced the Supreme Court to again hear the appeals of Guantanamo detainees, which Congress and the D.C. Circuit Court of Appeals had thwarted. Our demand was rhetorically, conceptually powerful. Give detainees a simple hearing and an opportunity either to prove their innocence or otherwise challenge the legal basis for their continued detention. And in the summer of 2008, in the Supreme Court case called Boumediene versus Bush, the court again ruled in favor of detainees, concluding that they had a constitutional right to challenge the legality of the detentions, which was a firmer legal basis than the statutory right recognized by Rasool. So yet another dramatic victory sent me and other lawyers into a kind of certainty of ultimate victory through the courts. Finally, we would have the hearings we wanted. And at first, initially, these hearings had their anticipated effect. Detainees, through their lawyers, challenging the factual basis of the detention won an astonishing 75% of the time in the lower federal courts. Something else happened around this time that contributed to our excitement, the election of Barack Obama, who spoke about Guantanamo and related Bush administration practices in the war on terror as an aberration of American basic values. He promised to right our course. Indeed, his first act in office was to order Guantanamo closed within 1 year, and he pledged to Arab audiences in Cairo that he would deploy a new approach. This all appeared again to finally confirm the comfortable American narrative. Sometimes we get lost in wartime, we abandon civil liberties, but eventually we tack back to normal. That seemed to be what much of the lawyers like myself at least wanted to believe in 2009. Yet, 4 years later, despite the promises of the Obama administration, very little has in fact changed. Rights have not taken hold. 166 men remain in Guantanamo, languishing in their 11th year of detention without charge or trial, without any immediate prospect of release, and are therefore suffering the inevitably debilitating psychological and physical effects of prolonged detention. All three branches of government now have coalesced to solidify unjust detention practices. Congress has imposed onerous funding restrictions on the president and has otherwise ginned up, I think, unconscionable hysteria about the dangers posed by simply even trying detainees in Article III courts in the United States. They have banned the funding for transfer prisoners to the United States for trials and made it difficult for the president to transfer even conceitedly innocent detainees to third countries. The D.C. Circuit Court of Appeals, which reviews all of the habeas petitions from the lower trial court in D.C., has acted as if it's basically an appendage of the executive branch. It has shut down completely the meaningful habeas review the Supreme Court had ordered take place. And this court, which I would stress is, I think, fairly political, at least on these subjects, and so far the right makes Justice Kennedy seem like Earl Warren, has reversed every trial court's decision granting a habeas corpus petition, and basically a signal there will be no way out of Guantanamo through the courts. Lawyers have stopped pursuing habeas cases. President Obama, the Nobel laureate, remember that, has abandoned any meaningful pretense, effort, or will to close the prison, doubling down on legal positions taken by the administration. In the last 2 years, the Obama administration has transferred only 5 men out of Guantanamo alive, and has transferred overall only 84 out of Guantanamo, compared to the approximately 500 transferred out of Guantanamo by the Bush administration. Indeed, 86 men, over half the population, have been cleared for release unanimously by an interagency task force of State Department, intelligence agencies, and defense agencies. And so, despite the jailer's determination that these 86 men are not dangerous or detainable, they remain behind bars. So much for the great writ of habeas corpus. So what's worse, despite the hope and expectation that Obama would, by abandoning them, render genuinely exceptional the Bush administration practices, we've seen a normalization of national security practices, as well as, I think, a seepage into other areas of our domestic law. From the perspective of normalization, we have indefinite detention. The Obama administration has defended the idea of indefinite detention without charge or trial in almost exactly the same way as the Bush administration, and thereby solidified previously contested and unstable legal principles into permanence. Like the Bush administration, Obama has sought to dismiss every civil case brought by victims of torture, extraordinary rendition, and unlawful detention against U.S. officials, even offering a full-throated defense of the state secrets doctrine he pilloried on the campaign. He's also exceeded the CIA demands by refusing to meaningfully pursue civil or criminal accountability for war crimes committed by Bush administration officials. Indeed, the only torture-related criminal investigation by the Obama administration is that of whistleblowers who have attempted to expose CIA practices. Also, the NDIA, the Obama administration has, despite tepid veto threats, twice signed the National Defense Authorization Act, including provisions that make it exceedingly difficult to transfer detainees out of Guantanamo, and that codify indefinite detention into our law. There's also been seepage into other areas of our domestic law. I think the most notorious of the Obama administration's dramatically increased practice of targeted killings through unmanned drones of terrorist suspects, including targeted killing of U.S. citizens. I think the legal policy behind the drone strikes is a close cousin of that in Guantanamo, and they're kind of symbiotic. Depends on expanding the battlefield outside of traditional boundaries, reaching into Pakistan, Yemen, Sudan, other parts of the Horn of Africa, even when killing United States citizens. and relying on a secret executive process instead of any form of judicial check in the form of due process. Other areas of seepage include, I think, increasingly expansive use of material support for terrorism charges, broad immigration detention and deportation power to target those suspected of supporting, ideologically supporting terrorist groups. Include the use of special administrative measures or communication management units in federal prisons that isolate in extremely harsh conditions suspected individuals in pretrial and after trial charged with terrorism crime. Or there's the deputizing of hundreds of municipal police entities to do national security work. CCR recently sued the NYPD for its massive human mapping, surveillance, and infiltration of Muslim communities in New York and New Jersey, which was undertaken without any modicum of criminal suspicion. And in responding to our suit, the NYPD did not deny the practice of surveillance. Rather, they doubled down on the rhetoric of 9/11 11 years hence, arguing that this is critical for national security. They even use terms like radicalization and mosaic intelligence gathering, which I know from the Guantanamo context. And of course, these practices are not wholly novel. They don't occur outside of a context. You know, there are practices that predate Guantanamo, mass incarceration, you know, harsher immigration detention practices and limitations on immigrants' rights. So there are, I think, interesting connections there, but we don't have, I think, much time to explore them. But what I next want to turn to is what happened to the rights we thought we were fighting for. Why was Jamal al-Dosri only left with a meaningless piece of paper? And first, let me say that I have no regret for the role that I or hundreds of other lawyers and activists played in representing detainees and challenging other aspects on the war on terror. I think it was a courageous and principled response to a genuine human rights crisis and fulfilled some of the highest aspirations of lawyering. Still, you've heard my surprise and frustration that rights did not take hold as part of our broader struggle, or continuing struggle against excesses in the war on terror. The rights, I think twice, were sort of held out before us like Lucy with the football, only to be pulled away at the last minute. And in the end, we learned it became very hard to fight for law in a lawless place. And the reason for this may not be surprising to the political scientists or anthropologists here, but for me, again, the liberal law professor who's trained in the neutrality of legal doctrine and the faith story of progressive American constitutionalism, you know, I've modestly shared my awakening to this nurturing interdisciplinary environment. And as I think many of you know, rights do not exist in a vacuum. They're not freestanding things or baubles that have a shape or mass on their own that can endure once they are recognized. They are utterly contingent on politics, not the other way around. They depend on membership, valid membership in a political community. Hannah Arendt famously defined citizenship as, quote, the right to have rights, by which she meant one could only enjoy sort of first-order rights, like the right to be free from a deprivation of life or liberty, if you were not deemed a legitimate member of the political community. And so the extraordinary violence of Jews, she reasoned, only happened after their political dispossession. So the problem for Guantanamo detainees, victims of drone strikes, Muslims unfairly treated in the United States, is that politically dispossessed as they continue to be, they have, this is a conception of a friend and colleague, Munir Ahmad, they have no right to have rights. And as such, rights can be taken away very soon after they have been recognized and are often hard to endure. And so what follows from this, if this is true? It seems to me it suggests taking a more modulated and long-term approach to struggles for justice in this age of endless war. It causes us to think about rights tactics and strategies slightly differently. And by these metrics, offer a more optimistic pass at the struggles of the past 10 years and hope for beyond. Here are a few possible conceptions of of rights. One, there's rights as recognition. Remember, I described the central tactic of the Bush administration as creating Guantanamo as a tactic of evisceration, legal, physical, and cultural. But only later did I realize that filing papers by linking our clients to the tradition of habeas corpus, by using courts and the public to speak about their innocence, their humanity, and their suffering, were demands for recognition. It's akin to the existential assertion of rights as a form of bearing witness. It says, I am here. And so the lawyer's role in this context is to demand her client's place in the community. That demand is almost as important as the recognition itself. The second conception is simply rights as resistance. Filing cases on behalf of the utterly dispossessed permits a politically oriented lawyer to use the courts as forums for protest. We can now talk, as we regularly do, about the failure of the courts for political and educational value, their limits to do justice and their capture by the political branches, and in so doing adopt the tactic of the legal scholar Jules Lobel, and quote, dragging the courtroom into politics. Understood as resistance, rights can also do more. According to Arendt, rights are indispensable to humanity. It stands between the state and individual, and without a demand for rights, an individual is absent humanity, just a naked life itself. So demand for rights can be seen as an attempt to blunt or mediate state force or violence. And so rights-based lawyering viewed in this way has been necessary and worthy because it's been an instrument to blunt the force of the state. I thought often during this period of Milan Kundera, the absurdist critic of Soviet totalitarianism, who wrote in the book of Laughter and Forgetting, quote, the struggle of man against power is the struggle of memory against forgetting. Because Kundera believed that the great tool of undemocratic regimes is to use their power to alter or reconstruct reality, he thought essential that artists, journalists, and dissidents make a record of their memory as a form of resistance and of truth. The lawyer's ability to give accounts of their client's humanity and their ordeal at Guantanamo, which would otherwise remain erased or distorted, is a form of mass resistance, and I think represents a small but important check against unchecked power and violence. A third strategy is one of transnational justice in place of rights talk. In light of the limitations of a rights-based strategy in U.S. courts, lawyers are thinking creatively about using alternative international forums to seek transnational justice. A number of examples include, pursued by CCR and other organizations, filing petitions in international bodies like the Inter-American Commission for Human Rights, and those bodies force the United States government to appear before the Commission and answer central questions that they're forced to answer once the court accepts our petition, like what are you doing to close Guantanamo? Why have you closed it so far? And put some modicum of pressure on the administration, regardless of the existence of rights for detainees. CCR, for example, has filed criminal complaints against the Bush administration officials in Germany, France, Switzerland, Canada, and Spain. The last set of filings are still under consideration, and get other courts to force other countries to grapple with criminality of U.S. government officials and put embarrassing pressure on U.S. government officials if they're asked to answer these tribunals. Other organizations have sued foreign governments like Poland, Romania, and Macedonia in the European Court of Human Rights for their role in torture and extraordinary rendition when it was undertaken with U.S. officials. So suing foreign governments for their collaboration with the United States. And those courts have granted judgments to the very same individuals who were denied any accountability or compensation in U.S. courts. Other entities have sued foreign governments in those foreign courts for their role in abuse. The Canadian government awarded Maher Arar, as a CCR client, denied any justice in U.S. courts for his extraordinary rendition and brutal torture in Syria. The Canadian government offered him $10 million and an apology from the Prime Minister. The United States, he got nothing. The UK has awarded millions of dollars to victims of rendition and arbitrary detention because of the UK's role in participating with the United States in these abuses. The Italian government indicted CIA officials and Italian intelligence officials for the successfully prosecuted, convicted an Italian intelligence officer for the rendition of an Italian resident to Egypt for torture. These kinds of actions can put pressure from outside on the U.S. government, regardless of whether or not individuals possess sort of fully cognizable rights. So let me close this way. I started this talk with a story about my client, which I would hope help frame the discussion that follows. So I'd like to end with another story, and to reinforce why I know there's undergraduates here. I don't want to sort of suggest total despair and hopelessness. Far from it. I mean, I think this work for me anyway was life-altering in positive respects, as well as some negative respects. So in August 2006, German officials, not the U.S. government, told my German co-counsel Bernhard and me the date that Murat would likely be released, which gave me enough time to fly to Germany for the occasion. On August 24th, 2006, Bernhard and I met the whole Kurnas family at a gas station outside of Bremen, Murat's hometown, for the 6-hour drive towards Ramstein Air Force Base, where we were told he would be arriving in the early evening. The day was full of intrigue. There were secret meetings with German officials to find out the location of the meeting place for the Kurnas family reunion. There were constant intrusive calls from German and American reporters demanding confirmation of a spreading rumor of his release, and there was almost overwhelming anxiety. While we awaited Murat's arrival in a Red Cross senior citizens home arranged for by the German government and run by an affable Bavarian lady, we saw through the window literally the huge C-17 military plane descending from the sky. It was Murat. Murat's mother, named Rabia, who had, I mentioned before, been fighting tirelessly and courageously for her son's release for years, as well as Murat's father, his two brothers, Ali and Alper, assembled together in a hallway on the 4th floor to greet Murat. Rabia, in particular, stood in front of the creaky elevator doors, and her anticipation built to an almost unbearable level as the elevator doors repeatedly started and stopped, puffed and creaked and gasped. Finally, when the doors opened, Rabia latched onto her son as if he might be taken away from her again at any moment, and with Murat in her arms, she wept helplessly for a long time. And in the incredible excitement of that very long day, including literally a 3 a.m. rush into the Kurnas home disguised, myself disguised as Murat, he disguised as me, past the swarm of waiting journalists, you remember one thing more clearly than any other. During the many hours that Murat and I had spent together in Guantanamo, his ankle had always been chained to the floor. And that day, for the first time, I saw Murat walk. Thank you.